also chair of Guam Hotel Restaurant Association.
Good afternoon, Milton Morinaga representing GVB and PHR Camp Micronesia.
Hong Im from GV and Nikki Taxi Service.
Kiko Kusasimo from Lupeng Residence.
Mary Scruggs from Department of Public Health and Social Services.
Teo from Lupeng Residence.
Roisin Wade, independent tax consultant.
Russ Young from Harmon Star Corporation.
Stefan New from GCIC Property Management and Guam Association of Realtors.
Mary Rhodes, President of GHRA.
Bart Jackson, representing Guam Visitors Bureau, Guam Hotel and Restaurant Association, and I'm a small hotel owner.
Thank you, and Senator Munya Barnes. Did everybody have a copy of all the bills, the draft bills in front of them? If not, just let me know. Joining me this afternoon, ladies and gentlemen, is my Vice Chair and also the Vice Speaker of the 33rd Guam Legislature, Sijus Masi, Vice Speaker, for joining us. I want to present these drafts to all of you, and I want to share with you that the first bill, which authorizes the Department of Revenue and Taxation to enter into a tax collection agreements with various transit accommodation brokers, that bill has no revisions. Number two is we have consolidated the bed and breakfast requirements and short-term vacation rental units into one bill with a couple of revisions based on our last roundtable discussions and, of course, public suggestions. And the third one is the civil penalties, and there has been minor revisions to that. And I want to thank all the folks and you folks for your contributions toward strengthening our policy on this bed and breakfast industry. I also want to share that these roundtables, bringing all the stakeholders together, has been incredibly helpful towards understanding and building the bed and breakfast industry. And the next step right now, ladies and gentlemen, is based on public and stakeholder participation, is to introduce these bills into the legislature and continue welcoming our visitors into our homes to share our unique culture and heritage and truly experiencing the warmth of who we are as island people. And it's all of you guys on this table in one way or another continue to work at providing that best service to our visitors. So I will do the rules of engagement. I guess if anybody would like to say a comment, I'll go to my room. I'll start out with my vice chair and then just, he said no, maybe afterwards. So we'll start from the chair, work it around. And if there's anybody who has a question and would like to yield, they can eye me and we can work that. Same rules as we did the last time. And I do know there's a couple other folks coming up, so if you need to leave right away, you can also tap me. And I think the former Senator Telo Taidagui, you have a comment?
Thank you, Madam Chairman. Madam Chair, we received these right here, and you said there's some revisions that were changed. We've studied what was handed out to us earlier, prior. Maybe if you can go through those changes and on our ones that we were given prior, so that we can make those notations. That would help us for any questions.
And one of the suggestions was the schools and all that came up from GVB.
Yes.
So that was a part of one of the add-ons that was put into the bill.
Thank you, Madam Chair, for recognizing that.
Okay, so again, let's go ahead and, if everybody has the copy in front of them, an act to add a new section 30109 and section 30110 and section 30111 till chapter 30, title 11, Guam Code annotated relative to authorizing the Director of Revenue and Taxation or his designee to enter into tax collection agreements with transit accommodation brokers. That really had no revisions. So if anybody has a comment or suggestion to add on right now, and again, we did leave the opportunity for comment, and we did, like I said earlier, receive several calls and some suggestions to be able to put in, and then we addressed those. So on bill number 1, any comments? John?
I just have one comment. I know the bill addresses a lot of responsibilities to the transit accommodation brokers, which basically will be making them responsible to report on behalf of the bed and breakfast or whatever service rental license that they represent. That's a lot of responsibility, but it only really talks about the responsibility of paying over the hotel occupancy tax, but it did not address the payment of gross receipt tax. So maybe this is a comment that I want to put in. In addition to hotels or any other that's under Title 30 or Chapter 30, I'm sorry, they're also responsible to pay ZRT. Grocery tax on the amounts that they receive from the occupants. That's the only comment that I was reading that, and it only addresses the hotel occupancy tax. Like hotels, they also have to pay the ZRT on what they receive, or under this trade or business, in other words.
Sure. I have 2 comments on that suggestions. Ms. Rhodes?
Actually, our Food and Beverage Committee met the other week, and we had discussed that. The onus does fall on the entities, whether you're a hotel or any other, to report the taxes, right? To report total gross revenues plus your taxes. And that should not be specific to just hotels, but any business. Think about all of the online. So I know that's a separate issue, but that's something Revenue Tax needs to always think about. A lot of online sales that take place. There are a lot of small businesses here on Guam that do sell online, and they need to record those properly. So I don't know, it does not fall in here, but we should probably recognize GRT, HOT, and any relevant tax. You should probably just open it up. Should there ever be, anything, you should always refer to any tax that is owed. But I think the intent here was to create, to recognize that they do owe hotel occupancy tax, but notwithstanding any other tax that is owed to the government. So we probably should put that caveat in there, notwithstanding any other tax owed to the government of Guam.
Yeah, because it's giving them already the responsibility to report on behalf of the bed and breakfast or service rental licenses that they represent. And they're also even liable for any hotel occupancy tax in the event that they collect those taxes. So the only other thing is that if we don't address this issue, then it still becomes liable for the owner of the premises to, if applicable, to pay the gross receipt tax.
I'd like to make a comment. Sure, please. Forgive me, I'm not au fait with all of Guam's laws, but the gross receipts tax is, if it's over 40,000, isn't that correct? So if you look at a site like Airbnb, only the top 5% of their earners gross over 40,000. And typically they will be earners who are operating more than one property, and it's not, they're not living in the property themselves. So I really don't think that this is much of an issue, the gross revenue tax, as much as the hotel occupancy tax is, because most of your users are not going to be liable for it.
When we're reviewing some of those records that are basically on the website, a lot of them represents many units, and units add up. So gross receipt may be an impact moving forward. In other words, if some company out there represents a person that owns 18 units or so many units, I think those add up, and they probably will go beyond the threshold of 40,000.
So are you saying that, I thought we were talking about B&Bs, but you can... Airbnbs, but doesn't some of this revision say that the owner or proprietor has to live in the accommodation? So they couldn't live in 18 units, could they?
Now that would be for the bed and breakfast.
Only...
But the vacation rentals is a different...
Okay.
Yeah. Yes. Vice Speaker, did you want to comment first? And then I'll have Bart Jackson.
I was just wondering, on the gross receipts tax, shouldn't, when Airbnb or the consolidator or whatever, the one that sells it online, collects the money, they also pay a certain percentage? I mean, they pay the owner of the property, right?
I'm not too sure what the arrangements are, but basically we're looking at what this bill is saying, that they're responsible to actually report and turn over the collection of hotel occupancy tax. So that every now and then when somebody occupies a room or rooms, they would have to collect the 11% on the value of those rooms.
Yeah,
and
so
hand it over.
Wouldn't that just make it the responsibility of this online company to collect the 11% for each night that they've booked for somebody, but then the amount that the homeowner or the owner of the property receives, shouldn't they be the ones that file their own GRT for the amount that they've received?
That's correct, but I'm just bringing it up if you wanna lump it, because they're already collecting the amount. I mean, if you get a certain amount of money, I'm just bringing it as a comment. I'm not really. It's just a comment. I'm not.
No, because I would think that you would have to, if like for a house or a unit, a online company was able to book it for me for 10 nights. So for 10 nights, they will collect the 11% and provide that to you under
Correct.
the agreement. But they would pay the homeowner for those 10 nights at whatever amount it was that they had agreed to rent it to the homeowner. And then that homeowner would be responsible for those 10 nights and then be responsible for their own 20 other nights that they may have collected from somebody else.
That's going to be a lot of confusion, because I'm reading this, that once these owners enter an agreement with this transit, that they handle everything. We don't want to be basically have them entertaining 10, 20 customers, and then a company out there with an agreement handle another 20 or 40. It is going to be a lot of confusion. I thought this bill was basically says that if you want to get into a contract, the owner has to agree that everything is handled by is this what it's saying?
I think, Mr. Camacho, the issue in this case is we know that for every room night sold, every single night, there's an 11% tax. And so this is an opportunity for you as Reventax to create a memorandum of understanding, working with Airbnb or Flipkey or any of the others, to arrange for the payment of that tax. I think you'll be pleasantly surprised at how sophisticated those companies are and how easy the information is available to you as Reventax about how many room nights they sell and what the rate is that they sold at, what their total revenue is over the course of a certain period. I think you'll be very pleasantly surprised. The challenge of doing any tax other than the hot tax is that there are other issues, as was pointed out, the $40,000 exemption. And so you don't know what the particular of each individual situation is for other taxes, but we do know that every time a room night is sold, be it in a B&B or a short-term vacation rental or a hotel, that there is an 11% add-on to the tax. And so in that regard, that's really all this bill, I think, if I have understood it correctly, All this bill is trying to do is to allow you to create a relationship where Airbnb or any of the other transient accommodation brokers collects 11% on your behalf and then forwards it to you. And the owner, of course, the owner of the property is still responsible for all of the relevant business taxes and operational taxes that come along with having a business. But in this case, it's only the 11% on a per nightly basis, which is all that they're really going to want to do anyway. And I think furthermore, you know, we're not reinventing the wheel here. Airbnb already does this. And these other companies already do this. And I think that once you begin a dialogue with them, I think you'll be pleasantly surprised at how these types of issues have already been settled by most of the other jurisdictions, and we're just kind of going along for the ride.
Are there any other comments on this bill? If not, thank you. Yeah. Ms. Maria?
I think that's exactly right, because at some point these big companies need to give the homeowner at the end of the year, whenever, a 1099, you know? And so before you renew his business license the next year, he has to show that he paid income tax and GRT. So that has to be spelled out clearly somewhere on a business license for, you know, bed and breakfast, I would think. Take it away from the big companies, leave it on the owner.
If there are no other comments, let's keep going. There are no other comments. We'll go ahead and move into the next bill. And if everybody, this is an act to amend sub-item JJ of Section 61103 of Article 1 to adding a new sub-Article 1 to Article 1. All of the Chapter 61, Title 21 of the Guam Code Annotated, relative to clarifying the definition of a bed and breakfast on Guam and to providing such requirements as are necessary and proper for their operation, and to adding a new sub-article to Article 1 of Chapter 61, Title 21 of the Guam Code Annotated, relative to authorizing a short-term vacation rentals on Guam and to provide such requirements as are necessary and proper for their operation. As noted from the first roundtable discussion, we had 4 bills. It was recommended by one of our other colleagues and a couple of other members, because we're working on the same chapter, that we can consolidate both bills. I will say that we have made, based on some of the suggestions, we've made a few changes from our last meeting, and one that comes to mind is a mayor's verification was added, which will be required in Section 61558. The previous E will put a cap of total number of guests to 4 guests per room. We added a additional verbiage to clarify this cap. This additional verbiage will ensure that all guests must have a bed to sleep in, and the room has a comfortable amount of space for the guests to move around in. The specified sizes of the bed are based on U.S. Standard bed sizes. So we did have a copy of that as part of the report, committee report on the U.S. Standard. 3, we've added a new H that states that listing your property to be used for transit guests, even if it is a part of a package tour deal and a package price, places that property under the jurisdiction of this law. Number 4, subsection I changes the verbiage a little so that the house policies are made available online for the guests to read before booking. Number 5, we made it clear that they are subject to the hotel occupancy tax. Number 6, we also made it clear that they are exempt from the hotel sanitation law. 7, we added a new section stating the sub-article will not apply to homes hosting exchange student. That was a recommendation that was included. as part of the exemption. And next, we consolidated the vacation rental units into this bill. We've exempted one on that. We exempted the homes that are hosting exchange students. We made it clear that they are subject to the hotel occupancy tax. And again, we exempted them from the hotel sanitation statute. Now again, these bill will be introduced. We will also have another public hearing where official comments will continue to come in and then further deliberated. So some may agree, some may not agree, but these were all recommendations that came out of the previous discussions, and we as the facilitators, as the policymakers, have incorporated a lot of the issues that have come up, and we've put it in. And then we can take it from there and move forward when we introduce the bill. And then if anybody has any opposition to that, and they can work their justification, and if the committee chooses that be deleted, that it can always be amended or substituted. So those were based on the last recommendation. So the consolidation, some of the these minor changes, and making sure that we, based on the last hearing, that they talked about making it clear on the HOT that they were subject to the hotel occupancy tax. Okay, so I'll start from Mr. Chair. Do you have a comment on that? And then I'll go to the Deputy General Manager. Sure, you can deal with them now, and what we'll do, if there's any questions, and if any of the folks on this table can't answer it or share their comments back, we'll duly note it, and if it needs further discussion, we will continue to work that in. But that's why I'm saying this, it's very critical that every question that we go ahead and note it down.
Sure, Madam Chair, thank you so much, and I think it's a great draft, and just for the record, GVB is very supportive of everything you've done so far. We want to make it a level playing field for everyone. We want to have enough rooms during our peak period, so I think we're on the right track. I have a question under 61558.
Tell me what page.
Section
and
A,
what-
it's page 7.
Page 7.
Line 13. It says, "No person shall allow occupancy or possession of any short-term vacation rental if the premises are in violation of any applicable zoning, building, health, or life safety." My question is on zoning. Is this use permitted in all zones or only in commercial zones? R2, H, R1? It's not clear to me. So where it says, it can't be in violation of a zoning law if you're operating, say, a single-family residence that you don't live in, as an example, that's in an R1 zone. Is that a permitted use in an R1 because you're operating a business? So it's just something to kind of clarify. And I think my personal recommendation would be to not be overly restrictive, or we won't have the industry. So just kind of pointing out, we want to kind of clarify that the zoning is okay to operate.
Duly noted on that one.
And the next one, and I don't really have an opinion, it's just a question, but it seems under the entire, we'll go to page 8, 9, 10, this whole section, and I guess if you go to page 10, item 3, around row 9, it says
Proof of owner?
Yeah, proof of owner's current ownership. And as you go back 2 or 3 pages, all of these, this application talks about the owner of record, and the owner's sworn acknowledgement. And so am I reading between the lines here that this is only permissible if you own the unit and not if you're leasing it and renting it out with permission of the owner? It's not clear to me because it doesn't say anywhere in here that it's only if you own the unit, and yet all the dialogue kind of infers that it's only in the case of the owner. So I don't have an opinion one way or the other whether it should be
We'll go ahead and
limited to
further,
owners, but it's just not clear to me.
Further
Otherwise,
clarify the technical verbiage on that one.
yeah, whether you want it to be owners only. That's all.
Yeah.
Thank you so much.
Thank you. Senator Titlery?
I was just ready to speak on that same question that you had. And if you look on the original draft legislation on page 3, the original one on letter D, it basically says you have to be an owner of the property in order to. This is on the original one that was sent out. Now, finding it on the one that was just passed out, I believe it's in the section, it's still there in the section, yeah. It'll be on page 3, letter D. And that's
B and B though. I was referring to the short-term vacation, they're separate, right? So the B and B.
We're on JJ, right? this
Yes.
one? Okay, yeah.
But this section is all part
On
of B
this
and
one.
B.
Okay.
And this other section I reference is short-term vacation rental, so different use, right?
Yeah, so that was actually a question that was brought up with somebody who asked us to bring this up. And it basically is whenever you rent a house, you can also sublease. It allows subleasing for another one, so it does need to be clarified.
Okay.
If it
Perhaps
can
at
and
a
cannot be
minimum, you
done
want the owner's acknowledgement permission if you're going to permit it.
within the
Okay.
lease agreement. Yeah,
Within the
that's,
lease.
yep.
Thank you. Duly noted. Any other comments or suggestions on bill number 2? Mr. Joe?
Madam Chairman, as an advocate of safety and security, I just need a clarification on page 5, section 61561, line number 24 and 25. It reads, bed and breakfast owners are not subject to the hotel sanitation. Is there some kind of, I'm pretty sure, but I just want some clarification that there will be an inspection and make sure
Yes.
that it's safe to sell.
I
I just want to get that clarification.
Okay, and we'll do. Based on the Department of Public Health and Social Services, the last roundtable discussion, there are different provisions of how the inspections are done, and there are major requirements to a hotel versus dwellings, family dwellings, and apartment unit complexes and all that. And I think there was a delineation of making sure that that was noted. So we will tag that and get a verification from Public Health with Mr. Nadeau and make sure so if we can make sure that that happens, because I do know that it was noted that there were 2 different processes, prerequisites that were needed, hotel versus apartments versus the bed and breakfast.
And that's my point, Mr. Chairman, is that it should be something there that they have to comply to some kind of a
Yes,
health certification.
definitely. So we can go ahead and note that. Mr. Jackson, Mr. Bart?
Thank you. I'm reading the same page 7, the code compliance verification form, where we agree that the property is applicable zoning, building, health and life safety code provisions. And I'm wondering whether or not that covers condo covenants, and whether or not, because there are condominium associations that don't allow any commercial enterprise. Obviously, renting one's unit would be a commercial enterprise if you're renting it for money, and whether or not the condo associations themselves have any protection under the law, and so whether or not the phrase as written, applicable zoning, building, health and life safety codes, would also include some protection for condo associations, and when covenants clarify or state that there's no commercial purposes. So that's just kind of a question, whether or not they're protected within that area.
That was my concern from the last time, because a lot of the CCNRs and condos do not allow short-term rental to begin with, and then, commercial may or may not be, depending on the building, right? But when you say it's got to be legal in all aspects and zoning, it would have to include, too, not going against the covenants, conditions, and restrictions of the condominiums, which are, you'd have to change a whole bunch of paperwork if you wanted to do short-term rentals.
And I'm not sure whether or not there should be a distinction between short-term rental and leasing for long-term, because I think most condos will still allow you, you can purchase them for investment and have them for long-term rental, lease. And that's a commercial, and I'm not sure whether or not this, so you have to distinguish between a long-term, and a short-term vacation rental, which I know a lot of condos specifically write into their rules as not allowing, so we don't have strange people in the hallways.
Ms. Mary?
Yeah, I would be concerned about that area too because insurance is not listed in here. I don't know if you consider that under safety, life, health and life, but to me that's more fire code and public health. But just in what we go through, even in the last 3 years with all of the changes from, you know, health certificates, sanitary permits, pesticides, housekeeping certifications, and now with the responsible alcohol serving, there isn't a category for this. And some places, like apartments, condominiums, aren't subject to those things. Imagine even OSHA with bloodborne pathogen and all those other things that they have to go through. Public health has been waiting to implement the health certificate law that was passed last year until the lab goes into effect and they start training. So all custodians will have, for example, in these public areas for commercial dwelling, to be required to go through those certifications with housekeepers and any custodian. So just listing it as a short-term rental, I don't know. It should be still subject to, because hotels are considered hotels, motels, right? Where motels could be short-term, if you consider it. So we may need some advice from public health on how they look at that. Not beyond what you were just thinking of, but also any other type of certification that's required. If they're serving, if they're providing services outside of
So delineation.
the dwelling. Right.
Okay.
I have a quick
Mr.
comment.
Tay?
Yeah. I just wanted to ask what the exact distinction between a motel and a short-term rental was, because as you mentioned, a motel can be a short-term rental.
That's the problem. I don't think we have a distinction right now, and that's what we're discussing. We're creating it. So as we're creating it, we need to consider and get the advice from all of those government entities that oversee regulations and the compliance departments to make sure that we don't miss the boat while we're drafting this, that this category is also recognized on their end. Because that's how I think it was missed originally, was we don't have a category for this, so just put it in bed and breakfast. So you have to think of every other government agency, not just RevTax. Because, like I said, with the sanitary permits, health certificates, and even pesticides, you wouldn't be required in an apartment condominium unless you're providing custodial duties. Because if you're just renting out a unit, you probably don't need to provide that. But if you are providing custodial duties to clean out, like housekeeping or any janitorial service, then those individuals fall under the public health rules for health certificates, pesticides training, bloodborne pathogen, all of those things.
Yes.
I think, Tay, the answer to your question is, it's the number of units.
Okay.
You know, that's the only thing that really makes sense, and the type of services offered. So that if you have, if you have a couple of rooms, then clearly you're not a motel. If you're selling rooms in your home, or a condo with 2 bedrooms or even 4 bedrooms, but all of a sudden, if you have a unit where you're selling 20, and I don't know what the official cutoff is, then it's a whole different ballgame. And quite possibly, as we consider the specifics, a single owner of 4 units, each of 5 rooms, selling 20 rooms, would that person be required to add the additional services? To me, a single owner with 20 rooms, selling 20 rooms, is a motel owner, and not necessarily a single unit proprietor.
And with the reverse, for example, bed and breakfast, even though they're living in the home, they're still receiving revenue and providing food and other things, so therefore they're still subject to public health's laws on health certificates being inspected and things like that, because they're actually serving food on premise, and they need sanitary permits and all those other things. So they're not, just because they fall under that tax, the Dave Santos Act with the threshold where they don't have to pay GRT, they're not waived from any of the other requirements that fall under those types of businesses.
Would you happen to know the exact cutoff line as of now?
For hotel and motel, if you have 4 or more rooms, then you're categorized under hotel and motel.
4 or more bedrooms?
4 or more rooms. That's the definition for hotel and motel.
So a living room, a bathroom.
No.
No, rooms that you're renting.
That you sleep.
Yeah.
Well, you're renting the use of a bathroom when someone
But
sleeping rooms.
Okay.
Actual units.
Okay.
Units. How about that? Yeah, because for example, there are a lot of apartment units that are even listed even for under GH rate, that where they have several units within that apartment, like the one near Pier Marine, for example. They have so many units that they rent out, and they're listed as a motel, hotel, and they rent out more than 4 rooms. So they are subject to hotel occupancy tax for those, but the rest of the other dwellings are actually residential units or for lease. But the other ones, they actually promote that they rent it out on a per unit, per night basis.
Yeah, I think what we'll do is we'll go ahead and work with the delineation, and I'll work closely with public health on that. Yeah, okay. Any other comments on the second bill? If not, Mr. Johnson. And Russ, and then Senator, did you have another comment? Anyone on the side? Okay.
Hi, I'm Russ. On the section 61560, number 1, if you recall years ago, the annual registration of corporations was required by the end of every August, along with a permit fee. At the very beginning, the application had to be notarized under a jurat, and it became redundant, and I believe Revenue Tax changed that requirement, and just a sworn a statement at the bottom of the registration was required. It wasn't required to be notarized. On this, it's saying that the application has to be, the application shall be furnished under oath on a form specified by the director. I don't want to see us shooting ourselves in the foot again. Is it possible to clarify, does that have to be a notary for this registration, a jurat, or does it just a statement at the bottom of the form to sign off that you swear everything is true and correct?
We can work. I think what we could do is we can, if you would like to answer that.
My regulatory staff is looking into this right now, so any changes, or I think we're doing our comments right now on all the particular bills. So we get to that, we can address that section that you just quoted.
We can also declare the penalty of perjury, so we can look at that also. Duly noted on
But
that.
it made it much more easier to file for corporations without chasing down a notary.
Yeah, that's right. Yeah. So, thank you. Reverend Tax, I will work with you on that one. Okay. So,
I have a quick
Jay?
comment. Yeah. On page 7, line item 18. I think this was mentioned last time, but we were requesting for some type of clarification on a period. It says here, lodging for a period of not to exceed 30 consecutive days. What happens if you go beyond that? That was the clarification we were requesting previously. So, okay.
Page 7, line 18. Short-term vacation rental occupants. Yeah. Thank you, Tay. Well, duly noted. Any other questions on comments? Yes, please.
Can somebody please clarify?
Okay, can you go ahead and talk into the, just so that the listening audience can hear, please.
The short-term vacation rental lease, can that happen in residential areas or not? what are you thinking? Where are you going with the legislation? Are you wanting this or are you not wanting it? I can't figure it out. Do you want to be able to have tourists come and stay? For example, I live in Riso. Most of the units there at the moment on Airbnb are not owner occupied. It's working fabulously from what I can see. The community like it, the tourists love it. But they're not, most of them are not in conversion zone areas. Will they, after the bills are implemented, will these short-term rentals be viable or not, legal or not? I can't tell. What do you want? What's the goal?
I think you're looking at the law. You know, my understanding is there are laws in effect relative to zoning requirements, and so the issue is going to be researched to see whether or not it will require a zoning change, or whether or not zoning, even of a residential zone, might allow this type of short-term activity. I mean, that's the question. It's not for us to answer at this point. No one wants to change a law that doesn't need to be changed. So right now, the senator's staff will be looking at zoning requirements to see whether or not this type of activity is viable and legal, and so that's the question at this point. And if it's not, then it'll require additional legislation or additional zoning changes. But for now, we're simply trying to identify whether or not it might be available in this type of zoned area. So that's what it is.
Well, there could be another mechanism in that sense of change. Instead of changing zone, you can always apply for special use permit in front of DNR, saying, "Hey, I have this zone. There's no residential area. There's no comment, public hearing kind of deal," and then get a special use permit for next 3 years or 4 years, so you don't have to go through. But that's another subject that I think the DNR or whatever can work on it, and if that is amendable or.
Yeah.
Yeah, the other option, of course, is simply to amend the zoning law to permit this section under all zones. That'd be simple.
Well, I think that's a separate process to this point. Because although there are some people who like that, there are residents probably in that area that probably don't want transient population. So there's a whole separate process to go through with Land Use Commission when you change out zones or get special uses or variances. So I think we have to respect that part of the process and just do what we need to do, which, through this committee and through the laws that are being drafted here.
Well, at the moment, so we're looking at Airbnb as one of the things we're looking at and getting revenue from it as well. If you plug in Guam on Airbnb, you come up with 128 options. If you plug in private room only, how many options you come up with? 25. So if you're going to make this bill so that the short-term vacation rentals are not legal, then you're getting rid of all those other options for tourists to stay in. So it's actually quite a big issue.
No, well, I don't know. I agree with her. I thought one of the issues that we have to make as a group, and eventually the legislature is going to have to make, is take into account everybody's individual special interest as a hotel owners or as GHRA. There is a new entity out there that could possibly be a means of attracting tourists to this island, and it's short-term vacation rentals, and it's B&Bs. And we have to make the policy decision that we, as the legislature of Guam, support this new industry, and in supporting this new industry, we're going to provide them with the protection under the law to exist even in residential areas, which may not meet with some of the residents, approval, but we're having to make a decision. I mean, we have hotels next to private homes. So it's not, we have to make some decision. And I thought, and I've been participating in this with the idea that I thought we could all meet, set our side, or at least state our special interest, what our concerns were, and try to see to make sure that we can accommodate this growing trend throughout the world on travel. You know, the whole advertising for Airbnb is don't go to Guam, go live in Guam. And so and we have to make that policy decision, and I think she's correct that it's difficult to read into this whether or not we're doing it or we're just making sure that it's not going to happen.
For what it's worth, so I agree 100% with what the senator just said. I just pulled up the zoning law in here, and actually not even a conditional use, but a permitted use under R1, which is the least restrictive, is number 3 is bed and breakfasts. So certainly the intent was there when you did this. So perhaps it's as simple as amending that to say bed and breakfasts and short-term vacation rentals.
I have a quick concern concerning the earlier mentioned comment about the delineation between a motel and a vacation rental. I know that public health mentioned that the delineation is between 4 units. So my concern is, let's say someone has a 5-bedroom unit and they wanted to do a bed and breakfast or a vacation rental within their house. Would that be considered a motel? I think there has to be some type of clarification on this. The other aspect is, I know that that delineation is probably a delineation that probably public health is making, but is that written into law? Is there a certain place where it does state that a motel is 4 units or more? And from my own understanding, GHRA does not have any currently as a 4-unit motel operator. They can't join GHRA. So how is that even considered a hotel motel?
Yeah, actually, GHRA, after the first roundtable, our board met and we approved back in March a new category for bed and breakfast as well as short-term rentals. So we have a category, and if it's less than 5, I believe it's $50 a year. So it's actually a very reasonable rate. And so if anyone with a bed and breakfast and or short-term rental, as long as you're properly licensed with Department of Revenue and Taxation and met all the rules or all the government requirements, we do have a new category. So in addition to Airbnb and bed and breakfast, we also thought of other types of things like food trucks, panhandlers, like those kinds of businesses. And so we created categories for that.
Okay.
But with regards to public health, all of those are actually in the laws, and so in the rules and regs for Department of Public Health and Social Services.
Okay.
But just based on the main concept of bed and breakfast concept, single dwelling, home ownership. Mm-hmm. That's the biggest thing to get across. Mm-hmm. Single dwelling, home ownership. Thank you. Any other occupants?
Homeowner occupant.
A homeowner occupant. Yes. One more comment? I heard that. Okay. Miss Maria and then Mr. Ross.
It's just on page 10, under 11, single owner's insurance. Is it spelled out somewhere what type of insurance? Because most people will say, oh, yeah, my house is insured, and it's like inside, it's that kind of thing. But it has to be some type of liability, especially written or special for transient accommodations.
Duly noted. Mr. Russ?
In reference to what she just said, I think Mark Baldega can confirm that most tour agents, if your customer is coming to Guam through a tour agent, require a liability policy of up to $1 million. So I think it should be something that reflects the same in protection for our tourists. The other comment I have is about large developments like Oka Towers or Alopane, Tumon Horizon. It's spelled out in here that in order to get the clearance from Rev and Tax, that the mayor has to sign off in the village where it's participating. There's a lot of large developments where the homeowners association does not allow transients, but they still get sneaked in. I would recommend that the management of the development, there be a place where they sign off saying that it is permitted in that particular development, because there's a lot of arguments in larger buildings between residents, so it would stop those arguments right at the doorstep if the manager signed off, just like the mayor does.
Yeah, that sounds good. Okay. Milton?
Just additional information. In Hotel Guam has a law called Innkeeper's Liability Regulation too. So I'm not sure if you want to apply that to vacation rental homes too, that they have to abide to the innkeeper's liability regulation that the hotel needs to. There's a law in Guam, so all the hotel put that sign on the door saying, as a rights to the people who occupy the hotel room, we have certain rights to claim. So that kind of regulation is there. So I don't know if that could be one of the things that they need to advise, since there's a law, and we should not exempt for people who has only 4 rooms. You know, they still accommodate people to stay in the room too, so they should have the same rights.
Okay. Any other thoughts? If not, can we go on the last bill? Last bill, folks, is an act to add a new Section 5112 to Chapter 51, Title 18, Guam Code Annotated, relative to establishing civil penalties for illegal operation of lodging and facilities. Based on the original intent of the draft, there's no major revisions. We clarified the timeline of when the department will issue notices. I want to stress that there are a lot of liabilities that can come with bringing up transit visitors into your home and turning a place of your place of residence into a workplace. We want to make sure that the health and safety and the well-being of the community are in order. And as committed on the last roundtable, we want to educate the industry of all legal requirements and have them follow. I mean, this is why we wanted to make sure that if there was any underground activity that was happening, that, you know, we are going to make sure that if anybody's violating, everybody has to follow the rules. If anybody is violating, then they're going to be stuck with penalties. And, you know, they're going to be hit, and they're going to be hit hard. And I do know that based on some of the recommendations and suggestions that came up, they said these penalties as drafted today are too harsh. But again, it is a placeholder. When we introduce this one, and then we probably will make some revisions based on what was talked about today. But this one will go as is, and unless there's an overwhelming need to change, then we'll work from there. We can either for or against, and I'd like to continue the dialogue and see where everybody is at on the public hearing for this one. We want to make sure that we protect the safety and safeguard our visitors and of course our community on hand, and make sure that everybody's above board and that this is a new industry happening all over the world. And one day I'll be like my good vice chair, the vice speaker, and continue to go visit other countries and experience their bed and breakfast concepts and their vacation stays, because he said they're great in a lot of places, right? Yep. Yeah. So with that being said, are there any comments or suggestions or recommendations on this last bill?
Sorry, I'm afraid there are.
Okay. No worries. I mean, you know, good that we're hearing it now.
Line 15 and downwards, that paragraph.
Page what?
Page 2.
Okay.
It was never the intention in developing the bed and breakfast industry that the business owners will acquire homes in residential areas to establish businesses in the residential neighbourhoods. Maybe it wasn't an intention, but we can see from the 2 years or 3 years now since the bill was implemented that short-term vacation rentals is mostly where it's at on the B&B bill front. Okay, 80% of them are short-term vacation rentals. So this is kind of suggesting that this is not something you want. Like if somebody goes into Mariso, not me, but I see opportunities there for people, and a house is derelict or not being used, and they buy it and make a business out of it. So they end up making a short-term vacation rental, using labor down there to clean, to do maintenance on the place because it needs to be maintained way more than if it was a long-term rental. I don't think this is a bad thing. And I've met the tourists firsthand, and they love staying in a place like Mauricio. And if, you know, I just don't want this taken away from the southern villages and from the tourists, because I think this is a really good thing.
Comment?
I think, that first sentence aside, I think the comment, the paragraph is more about those businesses that are not properly licensed than it is about discouraging the industry.
Okay.
I think it's not about discouraging the industry. It's about penalizing those folks who choose not to be registered, not to be licensed. And I'm on record. I'm on record for saying that I don't think the penalties are punitive enough. You don't wake up one morning and find, wow, to your surprise, someone is sleeping in the bedroom up in the front of your house. Wow, what a shock. Nothing happens without there being an awful lot of premeditation and effort. And if the same effort was made simply to be licensed and registered, then we wouldn't have any of these illegal lodgings, and everything would be okay. And I think I applaud the senator and the legislature for making an effort to legalize these things. But these things don't happen by mistake, right? So you have to work to get someone in your house. It's not a surprise, and you might as well work to be licensed and work to be registered. And if you choose to ignore that and choose to ignore the law, then I think you ought to be penalized, and penalized extensively.
Well, I phoned Rev and Tax and asked if I needed to pay occupancy tax, and I was told no. This was back in June.
Here we are.
We are.
That's why we're here. That's why we're here.
So make it simple. Keep
That's why
it
we're here.
simple.
Yep.
I knew that. I phoned 2 different times, because whenever I phone government agencies in any country around the world, I'll phone twice. And if I get the same answer twice, I'm usually good with that. But I did phone twice, and I got the same answer twice, which was no. I'm afraid I didn't. But I did ask for the information to be confirmed by email, and I didn't get any answer back. But I followed up on the bill and read for myself, and it's like, okay, this is needed. But it's easy to stumble. So as long as we're aware of that too.
Yeah. Thank you. Any other comments? Yes, Mr. Ross.
This is a little bit off the wall, but all of this discussion is for the benefit of the people of Guam, our taxes and revenues generated. But perhaps there should be an agency set up for the tourists to be able to contact in the event they have a bad experience. Perhaps GVB would be the good agency, but there should be some open exposure to the tourists to know they can complain.
Good comment, duly noted. Any other comments? Or Miss Maria, no worries.
I'm sorry.
This is why we're here.
I'm assuming there will be a body that kind of checks and makes sure that people are abiding by.
Well, Department of Revenue and Taxation would be that body for enforcement on this.
I mean, that physically go and check.
Yeah.
That they didn't just apply for 4 bedrooms and they've turned it into 18, right?
There's a complaint.
Okay.
Yeah, there's a complaint.
I just want to
process.
make sure, because I've seen it.
Yeah. And again, if you see that, there, you can always turn it in. There is a hotline provision for that, right?
Good.
Yeah. Thank you. If there are no other comments or questions or recommendations, I just want to say on behalf of the Vice Chair and myself and the stakeholders, I want to take the time to really thank you for taking time out of your busy schedule to be here. Based on everything happened today, we will do the follow-up. We'll take all the notes. If there are any other additions to these draft bills, we will make the necessary adjustments. If you sign up and give us your email, each one of you again will receive the the updated version of these drafts, and then we will introduce it. Our timeline for introducing it, I think I'm going to look at, today is Thursday. I'm looking at introducing it next week, Wednesday, making all the revisions Monday and Tuesday before PATA starts this weekend. So, did you guys, well, unless we want to do one more, what I'll do is I'll go, what we'll do is we'll go ahead and make all the necessary updates from today's roundtable. We'll send it out. I'm asking everybody who has not signed up, who wishes to get information of what's happening today, please sign in, give us your email so that we can make it a point to give you the updated draft. And then if we don't get anything a couple of days after we send out the updated drafts, we will introduce. Fair enough? If not, thank you very much for being here. We will call this public roundtable on the Committee on Municipal Affairs, Tourism, Housing, and Guam Preservation Trust to an adjournment. Saina Maasi for each of you coming here today.